This is Wills and Trusts, and we're on Chapter 9. This video will be about trusts, fiduciary administration. Your book discusses how, historically, trustees had very limited power. And over time, that limited power to administer the trust was expanded to a very general and expansive list of duties. But these duties, if you remember back to this slide from chapters ago, this duty has to fulfill the trustee's obligations. And his obligations are to enforce the trust instrument in a way that carries out the settlor's intent. And that often includes making distribution to a set of beneficiaries. If we have a revocable trust, we had said that the settlor is the one who basically owns the property, and because the settlor basically owns the property, they're the ones that can sue the trustee. However, in the case of irrevocable trusts, which is primarily what is discussed in this chapter, the trustee has a duty to the beneficiaries, and the beneficiaries have the right to sue the trust. So in an irrevocable trust, the beneficiaries can sue the trustee. As I mentioned in the intro, the powers of a trustee have increased over time, and courts generally give what can be thought of as maximum empowerment at this point to the trustee, so that the trustee is able to do almost everything that the owner of property can do. However, a trustee is held to a fiduciary obligation. And the obligation is primarily represented by two duties: a duty of loyalty and what can be thought of as a duty of prudence. There are also a number of subsidiary rules. Much litigation over trust administration can be put into two categories. The first category has to do with whether or not the trustee had the power to act as she did. Even if the trustee acted within her powers, did she breach her duties, her fiduciary? Generally, there are three kinds of trusts in practice. There are business trusts for commercial deals, and these trusts are created for commercial purposes, such as organizing a mutual fund or facilitating asset securitization. These are outside the scope of what I will test you on for this class. However, I do want you to know that these business trusts do exist. There are then revocable trusts for non-probate transfers. We talked about these in detail, in depth in a previous lecture. These are commonly used as will substitutes. Remember, when you convey property through a trust, it is at death, it is outside the probate process. So that's how revocable trusts are often used for what are called non-probate transfers. Then there are irrevocable trusts, and they have ongoing fiduciary administration. So they continue after death of the settlor oftentimes. And the administration of property by the trustee, like I said before, is done in accordance with the settlor's intent, but they do owe a duty to the beneficiary, and they're often paid for their services out of the trust. Right? So they are seen as a professional administrator of this trust. These irrevocable trusts are often used to maintain and to pass on intergenerational wealth. So one of the primary duties when you have fiduciary administration is the duty of loyalty. And we're going to talk about the duty of loyalty in the context of a couple of cases. Hartman v. Hartle. The duty of loyalty stated by the third restatement of trusts, says that except as otherwise provided in the terms of the trust, a trustee has a duty to administer the trust solely in the interest of the beneficiaries or solely in furtherance of its charitable purpose. With Hartman v. Hartle, this was a case where we had a will which directed executors to sell real estate and divide the proceeds amongst the children. The executors or representatives of that will sold the farm at auction for $3,900 to Lewis, who purchased it on behalf of Josephine, spouse of an executor. Josephine then sold the farm for $5,500 just a few months later, making a profit. The plaintiff sues the executors for self-dealing, and they were seeking 1/5 of the profit realized in the sale of farm by Josephine. The court held that it is settled law that a trustee who has the power to sell trust property nonetheless violates his duty of loyalty to the beneficiaries if he sells the property to himself without their consent. And this is true even if the transaction is in all other respects entirely unobjectionable. It is true that the farm was sold at auction to Lewis, but it was purchased on behalf of Josephine. For self-dealing, good faith and reasonableness are not considered a defense. So good faith and reasonableness may be a defense in other situations when you have a duty of loyalty, but not when you are dealing with self-dealing. There is a strict rule against self-dealing, and it is known as the no further inquiry rule. Once self-dealing has been shown, no further inquiry needs to be conducted by the court. That's it. The transaction is voidable by the beneficiary. If a trustee wants to engage in a transaction that might be considered self-dealing, they can protect themselves by getting advanced approval from the court. For judicial approval, the court is looking first to see that although the transaction is self-dealing, that it is for the benefit of the beneficiaries. Now let's go into the facts of Henry Gleason's will. So 2 weeks before Colebrook's lease was to expire, the lessor died, leaving the property to Colebrook in trust for the benefit of 3 children. So when Mary Gleason was alive, she leased 160 acres of farmland to a man by the name of Con Colebrook for a year. She again leased the premise to him for another year. Then she passed away. And in her will, she devised the farmland to Colebrook in trust for the benefit of her 3 children. Well, Colebrook's lease was about to expire and he was short on time. So he renewed the lease to himself for another year with an increase in rent from $6 an acre to $10 an acre plus a share of the crops. Then, a year later, he leased the farmland to another tenant. The question was there a breach of duty of loyalty by self-dealing when he renewed his lease? The court held that it was a breach of duty of loyalty. The court said that they generally follow the rule that a trustee cannot deal in his individual capacity with the trust property, and that's exactly what Colebrook did. He was on both sides of the lease. He was a lessor and he was a lessee. So Colebrook tried to argue that there were peculiar circumstances. He tried to argue that it was in the best interest of the beneficiaries, but the court was unimpressed. Once the fact of self-dealing or conflict was shown, then no further inquiry was needed. If we're going to apply the restatement to these facts, then we may get a little bit different outcomes. The restatement emphasizes that there are some defenses to self-dealing. But these defenses don't apply if the trustee acted in bad faith or unfairly. There are mandatory core fiduciary obligations that cannot be contracted away in the trust instrument. So a trustee may be authorized by the terms of a trust explicitly or by implication to engage in transactions that would otherwise be prohibited by the rules of undivided loyalty. However, no matter how broad the provisions of a trust may be in conferring power to engage in self-dealing or other transactions involving a conflict of fiduciary or personal interest, a trustee violates the duty of loyalty to the beneficiaries by acting in bad faith or unfairly. That is the minimum standard. Henry Rothko. February of 1970, Rothko dies, leaving 798 paintings of, quote, tremendous value. And he names Riaz, Stamos, and Levine as his executors. The executors disposed of the paintings within 3 weeks through contracts MAG and MNY. Rothko's children, plus the state's attorney general, sued to remove the executors and to rescind the contracts that they had entered into. Here are the findings that were made by the surrogate court. Reese, because he was an officer of MNY, had a conflict of interest. Stamos, who was a struggling artist, also had a conflict of interest because he was trying to curry favor with MAG and MNY. Levine, though not conflicted, acted imprudently by giving Reese and Stamos's conflicts of interest. So, although Levine did not have a conflict, he had a duty. If you are a co-trustee, there are certain duties that you have to not ratify your co-trustee's behavior, as well as acting in a prudent manner to prevent them from self-dealing. The trustee who does not join in an action of another trustee is not liable, but they must exercise reasonable care to prevent a co-trustee from committing a serious breach of trust and must compel a co-trustee to redress a serious breach of trust. Duty of prudence. The duty of prudence is in UTC section 804. And it says a trustee shall administer the trust as a prudent person would by considering the purposes, terms, distributional requirements, and other circumstances of the trust. In satisfying this standard, the trustee shall exercise reasonable care, skill, and caution. Some states have replaced this prudent person standard with the prudent investor rule, or have added on to the prudent person standard with a prudent investor rule. The prudent investor rule, you can think of it as how in torts there is a different standard for professionals than there would be for lay persons. The same applies here. If a trustee is an investor by profession, or they're an investment company, then they are compared with other investors. If it is a lay person that is the trustee, then they need to act as a prudent person would. However, if they are an investment company or a professional, then they are judged by the prudent investor standard. Sarah died in 1971. She left 1/3 of her estate in trust for her second husband, Cappy. All right? So Sarah was previously married. Then she was married to Cappy. She left her estate in trust for her second husband, Cappy, for life. Then the remainder would go to her daughter, Sally, and Sally's family. Trust instrument said that you can pay the income quarterly, but if you really need to, you can go into the principal if it's necessary or desirable, were the precise words. All right. This also had an exculpatory clause. So the attorney who drew up the will was also the trustee. And he put in this trust with the knowledge of the settlor, so he says, an exculpatory clause that said no trustee hereunder shall ever be liable except for his own willful neglect or defaults. Sarah and Cappy owned a house as tenants by entirety. So that was one of the assets. At death, full title of the property passed to Cappy. At Sarah's death, full title passed to Cappy because at death, so Cappy, just to complicate matters further, decided to get married to Margaret. And he executed a will drafted by the same attorney that is the trustee for this, leaving his property, including the house, to Margaret. Then Cappy, and well, we're not to the fact that Cappy died yet. First, Cappy told Farr, the trustee of the trust, that he really needed some money. Now, the trial court held that the requirement that Farr had to put this all in writing discouraged Cappy from making any further requests for principal. Farr, as trustee, made no investigations into the needs of Cappy. Cappy was admitted to a nursing home, and he ran into difficulties in keeping or maintaining the house. He could not meet the upkeep. So Cappy and Sally got into an agreement, his stepdaughter. So he owns this property outright. Be simple, absolute. then he takes it and says that if she'll pay for the maintenance, which is consideration, she would get the house. So basically, Cappy kept a life estate in the property. He executed a deed with a life estate in the property. And in exchange, Sally got the deed. She just had to pay for the maintenance. They went too far, the trustee, in his capacity as an attorney, to draft up this deed transfer. Now, at this point, Farr did, on behalf of Margaret, the wife of Cappy, ask Sally if Margaret could stay in the house after Cappy died, and Sally said no. But Farr didn't let Cappy know this. Then Sally dies. Then Cappy dies. And Margaret is asked to leave the house. She sues Farr. Because he didn't meet his duty of inquiry or his duty to distribute the principal. What was especially important in this case was that the trust instrument allowed the trustee to go into the principal. If it didn't, we might have had different. This also question of this case touches on a little bit about how much of the beneficiary's other resources should be taken into account when deciding how much of the principal or how much of the income to distribute to the beneficiary if our objective is to create a certain standard of living. Traditional law says that other resources are not to be considered when determining need. The case also had an exculpatory clause. Extended discretion, it's when the trustee, by the trust instrument, is given absolute, uncontrolled, complete discretion to do whatever they want with the trust property. However, we looked at the UT says that judicial review is still going to exist, regardless of what amount of discretion the trustee is given. And there will always be judicial review, and the trustee must always act in good faith. Exculpatory clauses are clauses made it so the trustee was not liable for his action. So if the trustee is the draftsman, the trustee must show under the restatement that there was a disclosure clause that was given to the settler and that it adequately explained the meaning of the exculpatory clause to the settler. Even with that exculpatory clause, though, they cannot excuse liability for bad faith, reckless indifference, or intentional or willful neglect. So there are limits. Mandatory arbitration clauses in trust agreements are generally frowned upon. These provisions basically make it so that any breach of trust must be resolved by arbitration. The settler chooses the trustee and sets it out in the trust instrument. Oftentimes, they will ask a friend or relative, and this is what we've been calling the layperson trustee. The settler, however, like I said previously, can name a bank or a trust company or an investment company as a corporate trustee, or they can list co-trustees. Now, let's say a settler appoints a layperson as a trustee, but that layperson is not comfortable deciding on an investment portfolio. They have the power to delegate the investment function. But when they delegate it, they must exercise reasonable care, skill, and caution in selecting that agent that is going to do the investing, and they also have a duty to monitor that agent. If they do not, they can be held liable for the actions of the agent. And here is the UTC rule. So as we said, the trustee that delegates is typically not liable for the decisions or actions by the agent unless they did not exercise reasonable care when they selected that agent or they failed to monitor that agent. Impartiality. So we have the duty of loyalty, the duty of prudence, and the duty of impartiality. This duty requires the trustee give due regard to respective interests of all beneficiaries while keeping in mind the settler's intent and purposes of the trust. It means that the duty of impartiality does not require that the trustee treat all beneficiaries equal, meaning she can distribute different amounts to different beneficiaries. But what the duty of impartiality requires is that the trustee give, quote, due regard to the respective interests of all of those beneficiaries. So as long as the trustee gives due regard, considers, thinks about, investigates the interests of all the beneficiaries, then the duty of impartiality is said to have been met. Now, impartiality problems can arise for both successive and concurrent beneficiaries. Concurrent beneficiaries often, the problems arise when you're dealing with distributing different amounts of money to different folks. When we're dealing with successive beneficiaries, we get the remainderment problem. How much of the principal should we allocate towards current beneficiaries, or how much do we need to keep for the remainderment? Those are considered successive beneficiaries. I've written some takeaways for Wilson v. Wilson, and we're going to end here. I just want you to know that to pay attention to the fact that even when trustees have sole and absolute discretion, they can still be subject to judicial review, and that courts think that a beneficiary's right to information is important because without it, courts cannot enforce the beneficiary's rights. All right. And with that, we conclude the material for this chapter.